So we are live, and I think we can start.
Yeah, Amrita ma'am, kindly start.
Oh, okay, sir. Okay, sir. Khushbu, over to you.
A very happy and pleasant morning to all our intellectuals, honorable guest speaker, and respected teachers. On behalf of KLE Societies, KLE College of Law, Navi Mumbai, I, Khushbu Kothari, welcome you all. I will be hosting today's session along with Professor Mohammad Salim Khan sir, who will be moderating today's event. Our guest speaker, Mr. Naveen Dahiya sir, has joined us. We welcome you, sir.
Thank you, Amrita.
Today, sir will be enlightening us on amalgamation, Indian context. I now request our principal sir, Professor Dinkar Gitte sir, to address our guest speaker and all the audience. Over to you, sir.
Thank you, Khushbu. A very good morning to all. A very warm welcome to our guest speaker, Mr. Naveen Dahiya. Uh, Sir happens to be my friend and my college mate, and he was a very intelligent student then, and a very good researcher, a good orator, and we had a very nice company in the institution of NLSIU. And Sir has Sir used to participate regularly in various conferences and other things. So, sir, on behalf of KLE Society's KLE College of Law, I welcome you for this August gathering.
Thank you.
Having said that, uh, I would like to also take a privilege and I would be very much thankful to my management, that is Dr. Prabhakar Koreji, who is the chairman of KLE Society, Shri Mahantesh Kaudgimat sir, director of KLE Society, GB governing body chairman and chief whip government of Karnataka, principal of KLE Law College, Bangalore, and all the GB members and all the members of KLE Society, all the participants, and all my students and teachers. Without wasting much of a time now, I think I would like to hand over this uh, session to Professor Mohammad Salim Khan for the further proceedings. Salim.
Thank you, sir. Thanks a lot. It's a privilege for us all to have Naveen sir over here. As a sir, I welcome you on behalf of KLE Societies, KLE College of Law, Navi Mumbai. Thank you, sir. Sir, a brief introduction about sir for the participants. Today we have Advocate Mr. Naveen Dahiya. Sir is the partner of UKCA and Partners, Advocate and Solicitors. Sir holds an LLB degree from Guru Gobind Singh Indraprasth University and a master's degree in corporate and business law from prestigious NLSIU Bangalore. Naveen sir has experience in in advising the clients in the areas of corporate, commercial laws, real estates, corporate advisory and litigation. Sir's forte lies in the area of corporate restructuring and strategizing investment inbound and outbound. He has been engaged in number of mergers, restructuring and acquisition of various multinational corporations and large corporations in India. Sir has been regularly representing several clients before various courts and tribunals across the country, including Supreme Court of India, various high courts, National Company Law Tribunal and its appellate tribunals, debt recovery tribunals, etc. etc. Sir's expertise lies in assisting the client in relation to real estate projects and advising multinational and domestic clients on various legal and commercial issues relating to real estate projects, conducing due diligence and assisting in drafting, reviewing, negotiating share purchase agreement, shareholders agreement, subscription agreement, joint venture agreements, business transfer agreement, guarantee, non-compete agreement, non-disclosure agreement, and other transactional documents. The CV is very vast. Sir, I am sorry if I have left something,
No, you have
but
covered most of the
but
things.
yeah, thank you, sir. Thanks a lot, sir. Sir, it's our privilege to have you here. The audience is very eager to listen to you, sir. Without taking any further time, I hand over the proceeding to you, sir, for your lecture. Thank you, sir,
Thank you.
and
So
welcome again.
before we start our session, I would like to take this opportunity to thank Director, the Kelly Society, Professor Dekkar Geete, and Ms. Amrita and other faculty members, coordinators, student conveners, other faculty conveners, organizing committee for this wonderful initiative that has been taken to conduct this national webinar series. So I'm really privileged and glad to be part of the initiative. So I thank everyone, and I would also like to make some, special mention as with respect to Professor Denkar, as we used to be the batchmates. And if I recall my days from NLS Bangalore, I would describe it as a melting pot of, multi-talented and diverse set of people which I have met. And Professor Dinkar was among one of those multi-talented personality. Be it academics, be it sports, or I'm sure you must be knowing that he's a great dancer. So I would like to make a special thank to Professor Dinkar for inviting me for this wonderful, initiative. Second thing, I would like to, I understand that this is the major audience will be students. So I also understand, and I'll apologize that I've kept this session for, Saturday, because being lawyer, Monday to Friday is really hectic. So that's why I requested I want to keep it on the Saturday. So I'm sorry if I have spoiled some of your plans, because the students mostly plan their things on, Saturday. So the second thing, and third, we can start with our session. I have a PPT to share. So, and I understand that most of the audience is students, and theoretical things are you have the learned professors, who can you. My focus will be on the procedural things when we do a M&A transaction. So theoretical, you can obviously you'll get the entire exposure from your college and university, but ultimately the practical things you learn when you join the profession, you do the exact transactions. So today my focus will be majorly on the procedural things, not on the theoretical aspects of the M&A transactions. So we can start. I have a PPT to share, so which I rely upon. Let me just see how to.
So at the bottom of the taskbar, you can see a green button, share screen.
Yeah, I can see. Is it visible now?
Yes, sir. Yes, sir. That's visible. And sir, at the top of the screen, on the right-hand side corner, there are three dots mentioned, and below it is written more.
Hmm.
From there, you can disable the participant annotation. You can click on more. You'll find an option, disable participant annotation.
Okay, let me just. Yeah.
Yes, sir. You need to disable that, and that's it.
All right, got it. Thanks, Amrita.
Thank you, sir. Thank you.
I'll just start it from. Yeah. So all set to go, Amrita. I guess you can see my PPT.
Yes, sir. It's visible, sir.
So let's start. So our topic is, mergers and amalgamation. If we see the term used is M&A. So in general parlance, M&A is mergers and acquisitions, but acquisition is a completely different set of, conduct code. So that will be governed under the takeover code. So today we will be focusing on the mergers and amalgamation and arrangements under the Companies Act. So, if we talk about a merger, I don't know what you must have already, in your curriculum, you must have studied like what is merger and acquisitions. So, under the Companies Act, mergers and amalgamation are, there is no specific definition. The term used under the Companies Act is the compromise or arrangement. Though they have used somewhere mergers and amalgamation, but there is no specific definition as to the term mergers and amalgamation under the Companies Act. So if we talk about the sections of the companies, that section 230, 32, 33 to 34 are the major sections which covers most of the transactions of an M&A nature. So I would start with section 230. So section 230 is a compromise or arrangement. If you see that a compromise or arrangement is a larger term. If we talk about the M&A, mergers are a limited thing, but compromise or arrangement can be a broader thing. You can have any sort of arrangement or any things of, you know, any nature under section 230 with your, the first class is a company and its creditors or any class of them. So under section 230, you can have some sort of compromise or arrangement with the creditors of the company. If you see that in any company, the major stakeholders are the company, its management. Then the second stakeholders, the major stakeholders are the shareholders of the company. And the third is the creditors of the company. So if anything is to be done, any major decisions are to be taken, some decision may be taken at the board level, board of directors of the company. Second, if there is a major thing which is happening as per the act, then that shareholders approval is also required. So suppose if the company want to enter, I'll give you an example, like first option is the creditors. So suppose you have some financial difficulties and you want to compromise. Suppose there is a, you want to say that instead of 100 will pay 60% of the debt to the creditors. So that can be an arrangement under section 230. Similar arrangement can be with the members. Members are the shareholders of the company. There may be different classes of them, equity shareholders, preference shareholders. So second thing is that you can have some sort of arrangement with the members of the company. So this is under section 230. So when there is no second company involved, you see merger, we see as a one company getting merged into the second company, not necessarily. Under section 230, you can have an arrangement with your purely with your members or with creditors or with both. So then we have to invoke section 230. This is the practical thing I am telling you, that if it's just a limited arrangement with the creditors and members and there is no outsider company involved, then you have to invoke only section 230 of that. But suppose if there is an arrangement or any compromise or a merger or amalgamation where one company or two company or three company and maybe more companies are getting merged into a subsequent third company, or the, you know, that we call, if the companies which are getting merged, we call them transfer companies, and the company in which they are getting merged, we call them as a transferee company. And suppose if the transaction is of that nature that two companies are getting merged into to form a third company, then we call the third company as a resulting company. So section 232 will come into the picture when you have an arrangement, maybe with your shareholders, maybe with your creditors, and there is a third company also involved, then you have to invoke section 232. So in amalgamation or merger, I will tell you like what happens is, like suppose I'll take a simple example, company A is getting merged into company B. So if company A is getting merged into the company B, the consequence of if the scheme is approved, then the company A will dissolve. All assets, liabilities of that company A will merge with company B. And the company existence of the company A will come to an end. So this is the natural consequence of a merger transaction. In India, we have earlier we used to have the jurisdiction with the High Court. Now we have the jurisdiction with the National Company Law Tribunal, which has the power to sanction, you know, schemes of arrangement under section 230, 32, or maybe under 233. I'll come to 233 later. But the power lies with the National Company Law Tribunal. And if there's appeal, which used to go before, you know, it used to be High Court, then the first appeal will go before the division bench of the High Court and then Supreme Court. But now the hierarchy is that the first NCLT appeal before the appellate tribunal, which is National Company Law Appellate Tribunal. If you are not happy with the order from the appellate, then you straight away go to the Supreme Court. This is the hierarchy. Section 233 is the fast track mergers. When we have now, earlier under the Companies Act 1956, we never used to have this kind of, you know, fast track mergers. But now under special cases, like with the small companies having, you know, paid up share capital up to rupees 50 lakhs and turnover up to rupees 2 crores. So they can apply for they can invoke section 233 for fast track. Fast track is basically, you need not to go to the tribunal for sanctioning of the scheme. You go to the central government. Central government will give you an approval, and for this purpose, the regional directors of the, you know, Ministry of Corporate Affairs have been given powers to sanction those kind of schemes. And the second category is when it's a scheme of amalgamation or merger between a holding company and its solely owned subsidiaries, then also you can invoke section 233. Though they claim that this is a fast track merger, but I still feel I have done like practically these kind of transactions. So we are not getting the actual result what for which this section 233 was inducted. I guess the regional director is taking more time what tribunal used to take. So then section 234 is the for the cross border mergers when we have like an Indian company merging with the outside company and vice versa. Earlier we used to have the provisions under the 1956 Act only with respect to a foreign company merging into an Indian company now, but vice versa is also permissible. So that is section 234. This is all has come into this new act, which is coming like 2013. So this is the broader structure of the under the act about the provisions which you need to invoke depending on nature of your transaction. So this is merger. Even there is a demerger, I would say there is no definition of demerger or merger. I said like earlier also. So demerger can also be a part of your section 232 when demerger is different from merger in a way that in demerger only one undertaking or two undertaking. Suppose there are multiple undertaking, business undertakings of a company. So if you have to take out one undertaking into some separate company, so we call it a demerger. So only the assets, liabilities pertaining to that particular undertaking will go to a third company. Rest of the company will remain in existence. The company will not dissolve. The company A will remain in existence, but only the particular undertaking from A will go to the B. So this is demerger. That is also part of section 232. That's why the term uses compromise or arrangement. Arrangement is a wider term. You may have any sort of arrangement. There's no need to that this is the kind of arrangements which are permissible. But the thing is that you need to have whatever arrangement is this as per the act. You need to have the approvals of the shareholders and the creditors both in 3/4 in value and majority in numbers. Your scheme can only go through when you have those approvals with you, maybe in writing in advance or maybe through a court convening meeting. So if we talk about the process of a merger, we'll start with first, if it's a we call it as a target company. If we have to acquire some company through the process of merger or amalgamation, so we transfer a company, we call it as a target company. So we need to see whether we have to conduct a due diligence first if that is our target. So we have to see whether all compliances are there are no hidden penalties, there are no hidden financial implications of the company. So obviously lawyers conduct a due diligence, they prepare a report for the entire company. Then we take a valuation of the company, that this is the value and at this value we want to buy this company. So that is, we call it as share valuation report. So we'll see that because ultimately if company A is getting dissolved, then the shareholders of company A will get some shares in company B in lieu of, because the company A is getting dissolved, not necessarily share, we may pay some other consideration also in some cash or like to individual shareholders. So this is the second thing, that you take a valuation, you see what are the financial things. If that is agreeable to both target company and the acquirer, then they proceed with they prepare a scheme, the draft scheme, we call it a draft scheme. If that scheme is agreeable to both the companies and their management, then the board approve that scheme. The first step of a scheme will be drafting and the second will be approval by the board. So once the board approve that scheme will go before the before the NCLT. We file it before the NCLT tribunal for sanction. First motion, we call in NCLT also there are two stages. First is the first motion. So we prepare the scheme, get it approved by the board and file before the NCLT. So first motion is limited to take the approvals from the creditors and shareholders. So either we generally in practice what we do is we take their approval in advance in writing on affidavits that this is the scheme and we have no objection if their meetings are dispensed with. Because otherwise if there is no approval from the creditor or shareholder, then the court will direct us, you hold the meeting, take the approval and then come back to us whether your shareholders and creditors are okay with the scheme. So but just to avoid that 2-3 months process, we take some advance approval if it's possible, if shareholders are internal shareholders and if the shareholders are agreeable or the creditors are agreeable. So we file that consents affidavit along with our first motion with the before the NCLT. And if it's the requisite value is there, then the court generally dispense with. There is also a lot of debate on the initially when this NCLT came into existence. Earlier it used to be High Court when jurisdiction came to NCLT. Then there are a lot of debates on these things also that we'll discuss in subsequent slides. So this is the broader thing of a nature of a transaction. Let's go step by step now. So like this is this provision came into force with effect from 15 December 2016. So now first question will come that who can file. So first, that under section 230-32, who can file a scheme of amalgamation. So if you go by the provision, can be filed by the companies involved in the scheme. They may file a separate application. They may also file a joint application under Rule 3, subclause 2 of the company. So I'll also that the act amalgamation or merger transaction will be governed by the Companies Act 2013. Plus, there are rules which are Companies Compromise Arrangement and Amalgamation Rules 2016, which gives a detailed procedure as to how to proceed with your scheme. So these are the provisions which will be mostly applicable if it's if there are foreign shareholders and if there are foreign stakes also in the companies, then all those. And if it's a listed company, then SEBI will also come into picture. RBI will also come into picture. That we'll discuss in subsequent. But today, now we are discussing who can file. So either the companies who are involved in the scheme can file. Any creditors can also file of the company if they propose something. Like not necessarily that the company has to propose a scheme. Maybe creditors decide that we should propose this scheme for the company. If the procedure is followed, that can also be approved. Similarly, members can also propose a scheme for mergers and amalgamation. And for those companies, if you see that winding up, that the company is already under liquidation. Earlier, we used to have winding up provision under the earlier act also before the High Court. Now we have the Insolvency and Bankruptcy Code also, where companies are into liquidation proceedings or into the CIRP process. So for those cases, the liquidator appointed for the company can also file such scheme. But the filing is different. Procedure will remain same. If it is filed by a liquidator or creditor, they have to their approval. The approval of other shareholders, creditors need to be there. So this is only who can file. So these are the fifth slide is for the format of application. That application to the tribunal be filed in form NCLT 1 along with the following documents. So these are the practical things that when you prepare a scheme, your scheme has to be in sync with the form NCLT 1, which is for the application for mergers and amalgamation, along with these document and notice of admission in form, affidavit in form, a copy of scheme, a disclosure in form. So these are the technical things, and I need not to discuss. You will get to know. So disclosure on affidavit by the company. So when you prepare a scheme, and I would also like to discuss the when you draft a scheme, what is to be taken care. I guess we are already ahead, but I would also like to discuss when you prepare a scheme, because the thing is when you join, if you intend to become a M&A lawyer and you want to join corporate law firms, so that's where this procedure is important, that you need to, when you intern also with the firms, then you get to know that. So this is very relevant, that you need to know the practical aspects of a transaction, that how you need to work. So when you draft a scheme, there are some crucial things which has to be there in your scheme. First thing is that you need to have a rationale and object of the scheme. That why are you planning this scheme? That this is the object which we are going to achieve by this transaction. So your scheme has to very clearly say that these are the object and rationale for the scheme by which we have proposed. Second, we keep definitions, of the general and the common things which are used in the scheme, so that tomorrow there is no contradiction as to what we intend to say. So that's why we define all, definitions like we have in agreements also. If we do general agreements, we keep definition that this means this and this means this. So that's the second important thing of a transaction, M&A transaction, of drafting a scheme. Third thing will be that you give all material information, financial, other information relating to company in the scheme. We take the latest audited financials of a company to be incorporated in the scheme, that as per the balance sheet of the company as in so and so date, which will be whatever your latest audited. This is the financial position of the company. This is the shareholding structure of the company. These are the details of the KMP. These are the details of the. So all material information relating to the company has to be there in your scheme. Third thing will come when we have the transfer vesting provision. Transfer vesting, when we say that when the scheme is approved by the NCLT, how this company is going to merge with what provision, that this will accounting, basically the accounting policies like this, if, how will you, absorb their accounts in your accounts. So all these details, and what will be, shareholding, like as discussed the valuation report. So how much you are going to allot to the shares, like what is the consideration involved. So all these things will be form part of your transfer vesting provision. Then there is another provision, accounting treatment, so that you have to make sure that what you are proposing in the transfer vesting provision has to be in sync with the available and applicable accounting standards which are generally issued. So that you have to make sure. Then we have a general terms and conditions of a scheme which we keep, that like what will happen to the employees. They're the most important things, because when you file these things before the NCLT, court will ask you that how are you treating your employees. Hope you are not terminating them. Like if the employees are there in the transfer company, when transfer company is going into the transfer company, so what provision you are making for the employees of the company. Similarly, what will happen to the existing contracts which of the company is a party, transfer company. We are talking about the transfer company. And what will happen to the proceedings where transfer company is a party. So all those things you need to take care in your scheme, that there is no objection from anybody later on before the NCLT. So that's the major thing. And what will happen, like other things also, like what will happen if there is any transaction in between when you file the scheme and before the approval. So how will you treat those things? Generally, we keep like a provision, like one technical thing is that we restrain as per the, because scheme is basically a contract between two companies, A and B. This is just, we call it a scheme, but it's purely a contract between two parties, that this is how we're going to govern our transaction before it is like after it is filed before the NCLT and before it's approved. Like one, I'll give you one example. We keep like the company A will not declare any dividend in between, so that will have a financial impact on me. So we restrain that during the process after filing and before approval, you are not going to divert, you are not going to sell any of the undertakings, you will not declare dividends in the company. So everything relating to those things we keep in the company. When you read a draft scheme, maybe there are 100 available for listed companies and everyone. So then you'll get to know that what is the main contents of the scheme, which, because sometimes small thing is missed out and then have a larger repercussion. So we need to be very careful when we draft a scheme. So then this is also like the disclosure on affidavit by the company, that the application shall disclose to the tribunal by way of affidavit. All these things are there in the Companies Act, that your application before the NCLT should have all those things. Latest financial position of the company, latest auditor report of the accounts of the company, the details about the pending proceedings before the company. You have to disclose that these are the legal proceedings or any other proceedings under the Companies Act or any other act are pending against the company. Because sometimes I've seen also that the people, use this route to, avoid something, some proceedings or anything of that sort to achieve something else, though the object will be something else in the scheme, but actual intent will be to achieve something else. So that also that court scrutinize when they give your approval, because ultimately when the court to file the scheme before the NCLT, they'll issue notice to all statutory authorities like ROC, Registrar of Companies, the Regional Director, the Official Liquidator, if it's a listed company, to the SEBI also, and to the stock exchange also, wherever shares are listed of the company. RBI also, if there is a foreign shareholders or foreign stake involved in the company. So all these statutory authorities will scrutinize the scheme, that whether it's in accordance with the applicable law, applicable accounting standards, and we are not violating anything. So that scrutiny will take place before the NCLT, and NCLT will issue notice to all. They'll file their representation before the court that whether they are okay with the scheme or whether they have reservations on the scheme. So that will come before the court and you have to address that. So these are the material information which you need to disclose in your application. So like I said, like the first thing is, the first motion what we are discussing here is, the first motion is only with respect to whether there is a need to convene the meetings of the shareholders and creditors, or whether those meetings can be dispensed with. Accordingly, you will have a prayer. Your prayer will be limited either to dispense with the meeting or to seek an order for convening the court convening meeting. When the court directs for the meeting, then it's a long process. Court will appoint someone from their own, that chairperson for the meeting, alternate chairperson for the meeting. Then there will be a scrutinizer who will, supervise the entire process. So that will be court convened meeting, then that's some completely a different process. But if you have the requisite consents in advance with you and you have filed with you, the court may dispense with the meeting, because the dispensation is a completely discretionary power. It's not that something you claim as a matter of right before the court. So that will depend. But if you could get them, if you can procure those consents before them, along with your first motion, it will be easy that you'll save some time on the transaction. Otherwise, because the 30 days notice period will be there and all those compliances will be there, you need to carry out a newspaper publication also. So there are a lot of compliances involved if there's a court meeting. So generally we avoid those meetings if we get the consents in writing in advance. So that is. So like is this that meetings of the credit tribunal may dispense with so I'll give a background of this dispensation thing. Like I said, there's a completely discretionary power. The term used in the act, even if we discuss the earlier act, which is the Companies Act 1956, the term uses may dispense with. So it's a discretionary power which used to lie with the High Court, and it's lying with the NCLT also. So there is no matter of right. But when this new act has come, the Companies Act 2030, there is a slight change in the provisions. Earlier there was no provision as to dispensation; it was a discretionary power. But now there is a provision which is Section 230, subsection 9, which says where such the tribunal may dispense with calling of the meeting of the creditor or class of creditors, where such creditor or class of creditors having at least 90% of value agree and confirm by way of affidavit to the scheme of compromise or arrangement. So this is something very new in the act under the Companies Act 2030. There was no such provision under 1956 Act. So when this provision came, so this says that when you have 90% of the consent of the creditors with you, the tribunal may dispense. It's still a discretionary power, not a matter of right, but tribunal may dispense with. So by adding this provision, they have created a confusion. Because before the High Court, though there was no such provision which says that under these circumstances you can dispense with the meetings, but High Court used to exercise their discretionary power, and under certain circumstances they used to dispense with the meeting, even there was no such provision. And there were other grounds also before the High Court. So if you have the consents, obviously they'll dispense with. Even if you don't have the consent, in certain circumstances, they used to dispense with without consents also. High Court, I'm talking about the High Court. So like suppose if it's a wholly owned subsidiary and a holding company, and the transferee company is not getting affected by the scheme because something is coming. The first ground we used to take is a holding subsidiary. So in case of holding and subsidiary company, you need not to allot shares. Like we discussed the valuation of the share. In a case of holding and subsidiary, wholly owned subsidiary, sorry, the exact term is wholly owned subsidiary, because the entire shareholding of the transfer company lies with the transferee company. So transferee company cannot allot shares to like its own. So basically, therefore, there is no need to allot any shares or to any consideration to be paid for those transactions. So in those cases, we used to say that, see, this is a holding subsidiary company. There's will no impact on the transferee company, because ultimately whatever assets are going to the transferee company, there will be no allotment of the share. So the shareholders of the transferee company are also not affected. Plus, if we see that the transferee company will have a positive net worth. So suppose today before merger my net worth is 100 crores. If we do this transaction, that company will be having a net worth of 110 crores. So they are having something additional and they're not giving away anything. So these are the cases of, I don't think there is a need of a meeting, because they are not adversely affected. Either shareholders or creditors, they'll be in better hands. Because if we talk about the creditors of the transferee company also, today they have a security of 100 crores. But after merger, they'll have a security of 110 crores. So that is something to their advantage. So they are more secured in that manner. So on those grounds, the High Court used to dispense with the meeting. But when the jurisdiction was transferred to the NCLT, and NCLT, after reviewing this provision, first thing they did is that the High Court judgments are not binding on us, because that was a complete different jurisdiction. So we can take our own view. Secondly, there is a specific provision. If they wanted to dispense with the shareholders meeting as well, they could have the similar provision like they have for the creditor. They could have similar provision for the shareholders as well. This is the second thing. So on those bases, they started refusing giving dispensation, even if you have 100% consent. So that's the first thing when it started in 2016, when because till 2016 jurisdiction was with the High Court. So in 2016 the jurisdiction got transferred to NCLT. So when the NCLT started to decide those matters, they used to take contrary views, no dispensation, it's a discretionary power, so we are not willing to give any dispensation. So entire purpose of the purpose of shifting the jurisdiction to a specialized tribunal was to make it everything very, yeah, I guess someone wants to ask something. Let me just see.
So we can take up questions during the question answer session.
Yeah, whatever,
Yes, sir.
I'm okay with.
Yes, sir. Because we ask the question during the question after your lecture is over. Then we'll take up the questions from the participants.
All right. Okay. Fine.
Yes.
So I'll take out all questions after this.
Sure, sir.
So
Sure.
we were on the dispensation of the meeting. So this is the thing that after the NCLT started creating issues with the dispensation, let's see. So that's the, I remember this 2017, this was the first case, JVA Trading Private Limited Company. So there, the company had 100% consent of the shareholders. They filed with the first motion and sought dispensation. Tribunal refused, stating, sorry, there is no provision for dispensation, and for the shareholders, there is a corresponding provision for the creditors, which if you get the 90% of value of the consents, we can dispense with, but not for the shareholders. So they refused to. So there was the first issue when then I guess that JV trading was by the National Capital Principal. There was a Delhi bench. So we have different benches for the NCLT, if you are aware of. NCLT benches according to the region. So if it's a northern region thing, the principal benches, the National Communal Law Tribunal, Delhi. So we have multiple benches across the country. So that time JV trading was before the Delhi bench. But the Bangalore bench in Coffee Day Overseas Private Limited, they took a contrary view and dispersed with the meetings, stating that when you have written consent file, so there is no issue, so they dispersed. So that created a further conflict, the issues in the jurisprudence. One bench is saying that dispensation cannot be granted, the other bench is saying dispensation can be granted. So, like we have discussed on perusal of the word may used in the provision of section 230, there could be two different interpretations. So, it's obviously a matter of interpretation. They said that may could have been used earlier, but now there is a change in the language because now there is a provision for the creditors. So, sorry, we can't. But we still felt that may is a broader term. They can't just cut away their own powers, that we don't have power to dispense with. Their view was we don't have power. If they just cut short their powers on their own, so that there is no purpose of transferring the jurisdiction to a specialized tribunal, because the matters were faster before the High Court, and the tribunal took the contrary view. So the purpose was, in my opinion, the purpose was defeated. So this is the rule 24 of the compromise and arrangement rules, which talks about the inherent powers. So when we argued some of the cases for dispensation, we said you have all the powers with you. It's a discretionary power. First of all, there's no provision which says that you can't dispense with. I agree that there is no provision which says that you can dispense with, but then the discretion lies with you. So you have to use your discretion in the favor of the stakeholders. You can't just complicate things by using your discretion for no reasons against the stakeholders. So that was one of our arguments, that Rule 24 also you have inherent powers with you. And then Section 424 of the Companies Act is very important. That is also we argued before the NCLT. See that you can Section 424 says that the tribunal will not be bound by this procedure, like the provision of the CPC. Generally, any litigation, any matter before the court, they have to follow the CPC Civil Procedure Code. But as per Section 424, CPC is not applicable before the NCLT. But yes, you will be guided by the principles of natural justice and subject to the other provision of the Act. But if you talk about the procedure, you need not to follow the procedure, but you are equivalent to a civil court under the CPC. If you read the subsection 2 of 424, the tribunal and the appellate tribunal shall have, for the purpose of discharging their function, under this act the same powers as are vested in a civil code. So as if it comes to power, you have all the powers, you have also power to regulate your own procedure. So if there is nothing specific about the procedure, you can regulate your own procedure. So that was one of our argument before the court. So 424, then so this is the like power like under the CPC also, like you can summon and enforce the attendance requiring. So earlier before NCLT we used to have company law board. So those before company law board we used to have summary proceedings, no evidence, no cross examination, no cross trials, nothing of that sort. There's a summary jurisdiction, limited jurisdiction. But after the Companies Act 2013 came, they have expanded their powers. So now the tribunal have vast powers like a civil court. Their orders can be enforced like a decree of a civil court, but with the benefit that the CPC is not applicable. You are not bound by the procedure laid down in the CPC. Like we have limitation, but ultimately through subsequent judgments, they have extended some of the provision of the CPC on the proceedings before the NCLT also. So this was the other argument, that you have vast powers, so you can't just curtail your powers on some narrow interpretation of the provisions. So this I have already discussed what used to happen in the High Court under the Companies Act 1956 Act, that we used to get dispensation. Even we used to we didn't had any consent of shareholders. But now the situation is really complicated, that you have the 100% consent, but still you are not getting the dispensation. And see, the law is what we feel is a common sense. Law is something which is very has to be as per the common sense. But if you have the 100% consent of the shareholders with you, the shareholders are saying, okay, there's no need to convene a meeting, we are giving our consent. So what's the point from the court directing them to convene a meeting, get that consent in that meeting, and then come back to the court? It's illogical also. If you go by the technical interpretation also, what they are claiming, it's completely illogical. Those people have given, like we are 10 people, we say, okay, we are okay with this. But the court say, no, I'll appoint a chairperson, I'll appoint an alternate chairperson, I'll appoint a scrutinizer, you follow the entire procedure. Then you hold a meeting and say yes there. You can't say yes here. So that is something very illogical. That was also one of our argument on that. So then these are some of the High Court judgments, which are also relevant, which we relied on the dispensation thing. We also relied on the doctrine of acquiescence. Doctrine of acquiescence is, I'm sure you must have read it, that when you have given your consent to something. So dispensation used to be on the basis of doctrine of acquiescence before the High Court, that they have consented to this. So there's no point convening a meeting through court convene meetings, So those are the things when the court used to give a dispensation. So these are also the judgments we relied upon. So this is the most important and relevant judgment on this. The Jupiter Alloys and Steel India Limited and another. So this was before Kolkata bench. So this was an interesting case on this entire jurisprudence. So what happened? The similar case was there. They had the consents, 100% consent of the shareholders, and they sought a dispensation from the court. So in the NCLT, generally there are two members. One is a judicial member, one is a technical member of the bench. So the two judges will be hearing your matter generally. So in some cases, there are single judicial members also. So judicial member can hold their court on their own without even technical member. But technical member cannot hold the court without a judicial member. So that's the thing under that. So there are two members. One is judicial and technical. Jupiter Alloy case. So one member took a view that dispensation can be granted, and he allowed the dispensation. The other member took a view, sorry, there is no provision, the dispensation cannot be granted. So there was a conflict in the one judgment. So what they did was they referred the matter to the principal bench, because the principal bench is Delhi, which govern all the other benches, or the coordinate benches of the NCLT. And they said that there is a conflict between the members. So generally, it's a matter of practice in the judicial process when there is a two conflicting judgments. Either they constitute a larger bench and then have a final say in the matter. So similarly, court appointed a third member on the bench and to consider the matter and then resolve the thing. So finally, the third member was appointed in this matter, and who took a view that dispensation can be granted. There's no reason to deviate from the jurisprudence evolved before the High Court under various, cases. There's no reason. There's no difference. Only difference is that the creditor thing is being included in the act now. There was no such corresponding provision earlier, but still, it's a discretionary power of the court, even the tribunal. So there's no point to deviating from the jurisprudence which has evolved over a period of 1956 Act and 2013, more than 50-60 years. So the High Court was not stupid. Like, they also have their mind and applied. And over a period, there are settled law on the subject. So why to unsettle everything? It's just the jurisdiction has come to NCLT. You just can't unsettle everything, and you can't just simply say that we don't follow the High Court judgment. So that was the view taken by the High Court, the NCLT, the larger bench. So this became a larger bench. 2 members were already there. 3rd member was appointed. So this is a binding judgment. And if it's a larger bench, the judgment is binding all the coordinate benches, maybe 2 member, 1 member, and even on the 3 members. Even if the 3-member bench subsequently want to take a different view, they can say that, okay, constitute a further larger bench, maybe 4 member or 5 member. Otherwise, you are, as per the matter of judicial discipline, you are bound to follow the judgments of your coordinate benches. You can't just take a contrary view. What happened earlier, that's it. So now, after this judgment, also there was some ambiguity, and now we are talking about the DLF Phase 4 Commercial Developers Limited. This matter I was handling. This matter was before the Honorable NCLT Chandigarh. So we relied on those judgment and sought dispensation even without any consent. In my case, the company was a listed company. So we had more than 3.5 lakh shareholders. So there was no possibility to, it's very difficult to convene a court convene meeting for a listed company when you have a shareholders running into 3.5 lakhs. So we sought dispensation on the basis of the judgment of the High Court plus the earlier judgment we just discussed, the Jupiter Alloys. So on the basis of these judgment, we sought dispensation, but ultimately Chandigarh Bank denied us the dispensation. They said, sorry, there's no provision, we can't dispense with. Then we filed an appeal before the appellate tribunal, which is National Company Law Appellate Tribunal, and we said there are judgments by the coordinate benches, there are judgments from the High Court. Even if they don't consider the High Court, they are supposed to consider, they are bound by the judgments of the coordinate bench. And now we have a judgment from the larger bench, 3-member bench. So they can't just simply deny us the dispensation. So we succeeded in the appeal and the dispensation was allowed. So we feel now it's settled that if you have the relevant things, maybe the consents, then the meetings can be dispensed with. If you have some other ground satisfied, like I discussed in the case of holding subsidy, you can seek the dispensation. So now that's the law on the dispensation. So this is the first motion. So suppose you don't have consent and the court don't agree, then there will be court convened meeting. So that is that process that upon hearing the application, the tribunal shall, unless it dispense with the meetings of the creditor or any class of the creditor, give a direction order in respect to calling of the meeting, such as. So this is I already discussed that they'll appoint some 3 people from the court that who will supervise the meeting. You have to issue individual notice to all the shareholders or creditors, as the case may be, for whose meetings you are convening. You also need to do a paper publication. Then there are certain other compliances also. Then date and venue will be fixed by the court, and then on that day meeting will happen, and the chairperson will see whether the requisite majority has approved the scheme or not. If it's approved or not approved, they'll file the report before the court. If it's approved, then you have the liberty to move the second motion. So now, up to now, we were on the first motion. So now we'll come to second motion. Second motion is where you seek the exact sanction of the court. First motion is only to dispense or convening the meeting. Second motion is to seek the sanction, approval of the scheme. So now first motion is over. Now we'll come to second motion. This is also with respect to how notice will be sent for the meetings and everything. This is, I guess, I'll share a copy of the PPT with. I already shared with Amrita. So if you want to read all this, you can read it from there. I guess because we have already reached to 12:50, we have 1 hour session and we are not even halfway from the. So this is all with respect to if the meetings are convened pursuant to the court order. So I'll just say they file the report. If it is approved, so scheme is approved, then you file a second motion before the court. Now that sanction my scheme, because shareholders and creditors have given given their approval. So now you please sanction. Approvals the same. Yes. So now this is the second motion. So upon approval of the scheme, the company shall, within 7 days of the filing of the report by the chairperson, present a petition to the tribunal in form number so and so for sanction of the scheme. So now we have come to second motion. Second motion, what they'll do is that once you file the second motion, the same procedure will be again followed. They'll issue notice to all the statutory authorities, like I discussed, ROC, Registrar of Companies, Regional Director, Official Liquidator, RBI, SEBI as the case may be, Stock Exchange, Competition Commission of India, if the relevant thresholds are crossed, and other statutory, the authorities or regulators. Suppose it's a, if it's an insurance company, the notice will also go to IRDA. If it's a real estate company, the notice will go to RERA also, or other district and town country planning commissions and all those. So whosoever is affected by the scheme, the particular regulator of that sector will get a notice. Notice will also go to income tax department also. So those people will scrutinize your scheme. Income tax would say whether you are planning to evade some tax by this transaction. I have seen a lot of transactions where the purpose of the entire scheme is to save some tax, because there are provisions under the income tax act also that when the loss making company is merging into profit making company, so the tax can be set, the tax of the tax liability of the profit making company can be set off against the losses of the loss making company. So there are a lot of things involved, not necessarily a bona fide scheme. Sometimes people prepare a scheme to save some money also. I don't feel bad, but if there are judgments also which says that if only the purpose of the scheme is only to save tax, then scheme can't be approved, then has to be rejected. But if you are saving some tax as a consequence of the scheme, but your object is something else, then that is permissible. So then section on presentation, they'll fix a date for hearing of the petition. They'll issue notice to the authorities. They'll ask for you to carry out a public notice by way of an advertisement in the newspaper, generally in 2 newspapers, one in the local language and one in English, having circulation in the relevant area where the registered office of the company is situated. And they invite objection. If anyone has an objection, they can file their objection either with the lawyer or with the tribunal. And then also 30-day period is given to the authorities who will file their representation before the tribunal within 30 days. If they don't file within 30 days, then it is assumed that they don't have any objection to the scheme. But generally, this is not the practice. Court give them, multiple opportunities. Their lawyer will come in the court, say, sorry, we were doing this, we were stuck, and we'll file in next 1 week or so. So as per the law, it is 30 days, but as a matter of practice, this is more than 3 months. So that's how it happens. So when the date will finally, then you have to file an affidavit of compliance that you have complied with everything. You have served notice to everyone. You have given a public newspaper advertisement. So that is being done. So finally, your petition will come for hearing. If there are no objection from anyone and there are no objection from the court will sanction your scheme. If there are objections, they'll consider those objections. If they feel that the objections are relevant, they might ask you to resolve those things. Maybe they can make some changes in the scheme. Court has power to modify the scheme that these relevant provisions can be modified. Or if they don't find that the objections are not relevant, they'll also consider your response to the objections. And if they find that these objections are not relevant, they'll simply approve your scheme. So this is the order of the court when they pass an order sanctioning the scheme, that how will it take effect. So there are 2 other most important things in the scheme, which is one is appointed date and one is effective date. So appointed date is something, the date on which you identify the assets and liabilities of a transfer company. Because transfer company is going to merge into transferee company. So you have to take some date, that is particular date. We will identify that as on date, whatever is lying with the transfer company, whatever assets, liabilities, that will belong to transferee company. So that is the appointed date. So the effective date is the date when the scheme come into effect, which is, as per the law, is the date of sanctioning of the scheme. So the day court sanctions the scheme comes into effect. But it will take effect from the appointed date. So today, if we are sitting on 31st October and my appointed date is 1st April 2020, so my scheme will come into effect from today, but will take effect from 1st April. So as of date of 1st April 2020, whatever assets and liabilities were there with the transfer company, that will merge into vest into the transfer company. So that's the most important dates which there was also a lot of controversy on these dates. And then then the entire assets liabilities will merge, the transfer company will dissolve, then accordingly your scheme, the employees of the transfer company will become the employees of the transferee company, and the some consequences of the amalgamation. So then once this order has come, then you have to file the merger order with the ROC, Registrar of Companies, appropriate concerned Registrar of Companies in Form INC 28, and the scheme will within 30 days from the date of receipt of the order. Earlier there was to be different provision under the 1956 Act, but now you have to file it within 30 days, because earlier scheme used to come into effect from the date of filing of this order. So suppose your scheme is sanctioned and you don't file your approval order with the ROC, so scheme will never come into effect. So what used to happen, people used to get an approval from the NCLAT, no, from the High Court. That time it used to be High Court. So we used to get an approval from the High Court and they used to don't file their order. So entire process is redundant. So now court has just to take care of that thing, they have said scheme will take effect from the date of approval, irrespective of whether you file the order or not. But this is only a compliance for compliance purpose. You have to file it within the ROC with 30 days of the receipt of the order, but nothing to do with the effectiveness of the scheme. Scheme will remain effective. So fast track measures, I initially discussed that for those companies having paid up capital to certain extent and plus turnover to some certain threshold, they can go before the regional directors. And if the companies are wholly owned subsidiaries and holding company, they can also file their application before the regional director. Process is little different, but even RD also took some contrary views, and ultimately the matters was referred to the NCLAT, because there is a provision under section 233 also that if you feel that RD feels that there is some non-compliance, so they can refer the matter to the tribunal also. So I feel 233 takes the same time, not if not less than even the same time for the transaction. So this is fast track merger. There was no such concept under the earlier act, but now we have. But so these are the provision for the fast track merger, and then these are the step-by-step procedure how to scheme along with how to file the scheme with the ROC. So I guess our slot is already over, so I may not be able to cover all the things. So I have already shared this PPT, so you can read all this PPT. So fast track, and then there is a section 234 which talks about the cross-border mergers. So I guess this will cover some other day, the fast track and cross border, because these are also completely different, provisions with substantial jurisprudence, substantial issues. So that is to be discussed. That I don't think we'll be able to cover. So that I've covered under 232, 32 before the NCLAT. Fast track and cross borders we'll discuss some other day. So with this, I conclude, and I would like to take all the queries which you have on the.
Thank you, sir. Thanks a lot. And really, it was an enriching part of knowledge for us all. Came across many new things. I will say practical new things to be more specific, sir. Thanks a lot for sharing that, sir. Sir, with your due permission, may I start the question answer session?
Yeah, please, sir.
Thank you, sir. Sir, the first question is from Amrita Verma. She says that, sir, can you give some examples of merger and amalgamation of Indian company and effect on the shareholders? Want to know recent example of both within reference to India.
Sorry, I didn't get the question. Can you
Okay,
just
sir.
repeat?
Yeah. I'll break up. I believe she has mixed 2-3 questions, sir. Sir, can you give some examples of merger and amalgamation of Indian company and its effect on shareholding She want to know the recent examples.
Okay, so how I'll tell you how shareholders can be affected by a scheme. So I'll give you an example where we filed our objection in one scheme as a shareholder, and there was a scheme when a company was getting merged into company B. So company A was a profit-making company, having substantial profit, no lesser liabilities. They plan to merge that company into company B, which was a completely shell company, no assets, no business, and lot of liabilities. So obviously, if I go from a better company to a worse company, my shareholding today, my worth is, because ultimately shareholders' worth is their valuation. So if I'm worth is 100 rupees share, if I go to the transferee company, which is worth in the net worth is negative, so I'll be losing. Might be today I'm holding 100 shares of this transfer company, but if I'm going to the transferee company, which is a loss making company, I might be getting 1,000 shares, but my worth of those shares will be negative. So that was the case there. We filed our objection. Sorry, we don't want to go to that company, because ultimately transfer company will get dissolved. So my profit making company will get dissolved. My shareholding will go from that company. Shares will be allotted in the transfer company. Transfer company is a shell company with no business, no nothing, no net worth. So my worth of the shares is getting negative. So we filed that objections in the court, and that objection for considered scheme was rejected. So this is one of the case where shareholders were adversely affected.
Thank you, sir. Thanks a lot. Sir, the next question is from Dr. Shobha Gulati.
Yes.
Uh, Ms. Gulati says that what are the provisions for merger and amalgamation of banks, both private and PSUs?
Okay. So provisions will remain the same even for the banks, and the provision will be invoked. It's just that the notice will go to RBI and all everyone. But I guess the provisions of 230-32 will be invoked, and there is provisions for which the government can also order the mandatory mergers of the banks, like it happened earlier also. So the provision will remain 230 to 34 of the Companies Act, because all are the companies, all banks are the companies incorporated into the act. So provisions will remain same. Procedure will be little different. Maybe it's a compulsory and mandatory merger from the government, because there is a powers with the government also under the act, by which they can order merger of certain companies, certain banks. To that include banks also, but just the process will be little different.
Uh,
So
Thank you, sir. Thanks a lot. Sir, the next question is from Harsh Kant. Harsh asks, what has more power, NCLT or High Court?
certainly High Court. They are very decisive, and they, because the level of High Court is completely altogether different. They have inherent powers, they have constitutional powers. So they were not they were not scared of taking blunt and bold decisions. But here, the in NCLT judges are little reserved, that maybe it may or may not be permissible. So certainly I felt that the procedure and the proceedings were much better before the High Court.
Thank you, sir. Thanks a lot. Sir, the next question is from Akshay Sheth. Akshay asks, in a conglomerate merger, how does corporate synergy arise? Or the primary motive is just profit creation and enlarged market share?
See, even in any merger, if you take case of any merger, it's just we claim it as a enhancement of the shares value, the value of the business. So the synergies can be, generally if there's a either two similar line of businesses there, then company A is also in the similar business, company B is also in the similar business. Obviously, then the due diligence will. The reason for conducting due diligence is to make sure that whether we are enhancing actually the value, or we are taking it So obviously, when you have a target, you will see whether there is a value enhancement or not. But in other mergers also, when the companies are into different line of business, maybe I want to, today I'm doing only one business, I want to expand in the other lines also, other verticals also. So that is also purely a commercial decision. You can't just comment generally. You have to have something, the figures and balance sheets and the due diligence report and all commercial, which is to be considered while taking the call on this.
Thank you, sir. Thanks a lot. Sir, another question is again from Akshay. He says that along with provisions of Companies Act 2013, what is the how relevant are Competition Act, specifically Section 3 Anti-Competitive Agreement, Section 4 Abuse of Dominant Position, and Section 5 which is combination.
Yes. So obviously, like I discussed in my presentation, that approval of the CCI will also be required if the relevant thresholds of the crossed. So not that in all cases CCI is a party, but if the relevant threshold as mentioned in the Competition Act 2002 are there, if those are met, so the notice will go to the CCI. So CCI will examine the scheme from that perspective, whether if that sanctioning of the scheme and this kind of arrangement will result in abuse of any dominant position or any cartelization. Maybe it's just the two dominating, two giant leaders of that particular sectors are getting merged. So they'll kill the entire other, small players in the market. So the CCI will definitely examine the scheme from that perspective, that whether there is any violation of the provision of the Competition Act or not. If there is no violation, definitely they'll give an approval. But if they have some reservation, those will be considered by the NCLT and accordingly will be the decision on that approval of the scheme will be taken.
Thank you, sir. Thanks a lot. Sir, the next question is from Sandhya Ved. She says that, sir, can a merged company still enjoy status of autonomy?
Merged company.
Yes, sir.
So you mean merged company by the transfer company, right?
Yeah.
So transfer company will not remain in existence. That company will dissolve. So that completely non-existent company. The ROC will also remove all the references from that company from the ROC records. So autonomy will not be there. The company will not be there. So there's no question of any autonomy of the merged company.
Sir, the next question is whether unfriendly acquisitions or hostile acquisitions are bound by specific laws.
Yes, that I discussed that the acquisition will be under the takeover code. So even if there are hostile takeovers, there are a lot of cases where hostile takeovers have taken place, but that also has to follow the takeover code. That the acquisition, if you are slowly acquiring certain stakes in the company, you have to make a public disclosure. So that provisions are there in the takeover code. So that if you whatever you do, you have to follow those procedures.
Thank you, sir. Thanks a lot. Sir, the next question is from our student from final year LLB, Vandana Vishwakarma. She says that which authorities get affected by amalgamation in Form CAA 3?
CAA 3, I just need to. Can she just refer the relevant? I don't recall what form CA 3 is. There's a lot of forms.
Fine, sir. I'll try to connect her. Sir, the
Letter.
next, sure, sir. Sir, the next question is from Akshay. He says that is post-merger employees retention a priority of NCLT or minimizing layoff is the way to go?
See, there's no as such provision in the act by which you are supposed to. Arrangement can be between you, your company, shareholders, and creditors. So NCLT can't force you to have the all the employees. You can't terminate also, but court generally don't see it as don't appreciate this. So they generally make sure that because the regional director they generally take this objection that what they have done with the employees. So there is no as such specific provision in the act which you have to follow that you have to retain the employees. If you feel that I don't want to retain, you can have those provision in the act. But generally, court don't appreciate. But I don't think that the court will dismiss this scheme if you have terminated their services.
Thank you, sir. Thanks, sir. Some more question with your permission, sir.
Yes, sir.
Sir, some questions from the YouTube viewer. One of the viewer asked, what is the procedure for merger and what is the scheme of amalgamation?
So both the terms have been used interchangeably, I would say. So if you see the act, terms are used, but there are no definitions of the merger. So practically, we use both the terms when we draft a scheme. But theoretically, if you ask me, so merger is when two companies merge and form a third company, resulting company. This is the theoretical definition, but I don't think that practically this definition exists. When we do a simple amalgamation, when one company is merging into the other company also, we sometimes refer it as a merger amalgamation. But as such, when we say that there is no definition of these terms in the Act, so these are used interchangeably. Amalgamation is defined under the Income Tax Act. So that is also a broader definition which includes all sort of arrangements. So if you see section 2(1)(b) of the Income Tax Act, you will find the definition of the amalgamation, but merger is not as such defined. But like I said, when we discussed theoretically, amalgamation is being considered when a company is the small company is getting merged into big company, or maybe forming third company, or two companies are merging and forming a completely new company. So these are the terms which are used interchangeably, no hard distinction. But when we do the transaction, we simply don't consider whether it's a merger or amalgamation. If A is merging into B, it's simply as amalgamation.
Thank you, sir. Thanks a lot. Sir, the next question is again from the YouTube viewer. He asked how the employees of transferor company is protected.
In a scheme,
Yeah.
so that depends on you how you draft the scheme. You may say that in your scheme, because that's a contract between A and B. Even if the employees are there, they will be governed by their respective employment agreements. So even if you are preparing a scheme, you have to still follow those terms and conditions what are there in their agreement. So suppose if you say that you can terminate them with a 1 month notice, you can terminate them. If you are preparing a scheme, you are not bound to retain them. But depends on you how you want to retain them, whether you want to terminate them, but you are still bound to follow the relevant, employment laws and employment agreements and contracts with the respective employees. But there is no obligation that I have to just ensure that I am in compliance with all the employment laws and employment contracts. So rest you can decide on your scheme, but there is no provision as such in the Companies Act which says that the employees has to be protected in this manner.
Sir, the another question is from one of the viewer. What are the authorities whose approvals are involved?
So as such, the approvals are not such that their approvals are required. They are just supposed to give a representation. Approval will be finally given by the NCLT on the basis of the representation. Obviously, if those authorities say no, so definitely NCLT will consider, and on the basis of that, but as per the Act, their approval is not mandatory. That's a representation which is required. They may or may not give. See, generally, those authorities are the ROC, Registrar of Companies, the regional director, official liquidator. If the company is getting dissolved, then the official liquidator. If it is a listed company, then SEBI also will be there. If it is a foreign shareholders in any of the company, then the RBI will be there. And if it's a listed company, then the notice will also go to the stock exchange on which the shares are listed. And the other sectoral regulator, if it's an insurance company or bank, so accordingly depending on the nature of the company.
Thank you, sir. Thanks a lot. Sir, the next question is there any criteria for mergers?
Sorry?
Is there any defined criteria for mergers?
No, there is no as such criteria that I told you there's completely a commercial decision between two companies with the consent. Can't be imposed. Yeah, can be imposed on the minorities. If you have, like suppose you have got the requisite consent of 75% in value. But what about 25% if they are not happy? If they are not happy with the arrangement, so they can file their objections before the NCLT. But as per the law, only shareholders or creditors who have 5% of value. Suppose I hold a shares to 5% in value of the total capital, then I can file my objection. Similarly, for the creditors also, if I hold the 5% of the total debt of the company, I can file my objection before the NCLT. Those objections will be maintainable. But still, I've seen cases the people below those threshold below 5% have also filed their objections. So court have considered those objections also. So there's no as such criteria. It's a purely commercial decision which will be finally approved by the stakeholder.
Thank you, sir. So the next question is, what are the benefits of merger?
Again, I would say, sir, that's a purely commercial, I can give you some examples, but completely a commercial decision of the management or the member. Suppose, like benefits could be like I discussed. If the companies are in similar line of business and they see that this company A transfer company has potential and likely to grow and expand the business and having its business units or business establishments across the country, so if we merge this company with company us, then we'll have that those resources at our disposal, all those establishments at our disposal. So this could be the one consideration which I'll consider when I decide a target. Secondly, like if we see that I want to expand my business into different verticals. So suppose today I'm only in garments. Tomorrow I want to go into the retail sectors and other sectors also. So I might find some target who is I can value their I can take a valuation and see that on what commercial consideration I can acquire that company. If I acquire that company, I'll have a different verticals of business. So for the expansion of business also, so it depends on case to case on what's there in your mind. Sometimes I've seen cases where there's no business consideration. It's just simply that they see that the company A is a subsidiary, become a liability on me. I have to do annual compliances of the companies as per the act, do a lot of things for that company, spending a lot of money in maintaining that company. So let's merge that company with the transfer holding company so that I could save those expenses. So depends on the case to case.
Thank you, sir. Thanks a lot. Sir, one last question, though I have many, but your time is also very precious for us.
Yes, sir.
Uh,
Please.
a last question, sir. What are the taxation benefits on mergers?
So taxation benefits again, it's like very commercial things you have been asking me, and the audience have been asking me. So because we are lawyers, so we are not supposed to get into. And
Commercials.
if some client would come to me and say that I want to save and tax, and that's why I want to propose this transaction, I would say sorry, this transaction will never get through. If the income tax department will scrutinize your scheme, and if they find that you are saving some tax, the purpose is to save some tax. So then the court will never approve. But as far as the other general benefits which we see that clients generally get in the scheme, so like I said, if it's a loss-making company going to a profit-making company has some tax liabilities. So if we merge that company with the transferee company, so there is a provision under the income tax act that by which you can revise your returns. You can open your accounts and revise your annual returns which you file with the income tax. So if you file that revised result, your liability will decrease because those profits and will be set off against the losses of the transfer company, which was a loss making company. So you might save some money there that you have paid 1 crore of liability, but after merger, that liability may decrease from 1 crore to 50 lakh, 40 lakh, or maybe you need not to pay anything. That the losses are huge in the transfer company. So this could be one of the benefits. Second time, sometime you get, accordingly the accounting treatment depends what benefits you'll get. The book value will go to a fair market value. The assets which are there in the transfer company, in a particular book value, that will go to the transfer company. Sometimes they propose an accounting treatment in which they'll be reflected on a fair market. So your 200, suppose example, your value of your asset today in the transfer company is 200. But when you merge with the transfer company, you take a fair value and you give it 400, which is appreciated over a period of time. So you don't pay anything from that appreciation from 200 to 400. So these are small things which generally the chartered accountants, the tax consultants who advise the company that if you propose a transaction like this, you might be able to save some money.
Thank you, sir. Thanks a lot for your valuable time, your inputs, and really appreciate the marathon answers for the marathon questions. Like every good thing comes to an end, we would be coming to the end of this seminar. I request Khushbu to kindly propose the vote of thanks. Thank you, sir. Khushbu, over to you.
Thank you so much, sir. I'm grateful to have this opportunity to propose a vote of thanks on behalf of my honorable college, Kelly Society's Kelly College of Law, Navi Mumbai. I extend my heartfelt gratitude to Mr. Naveen Dahiya, sir, for taking time from his busy schedule to honor this event with such an interesting and informative session. We have learned a lot today, sir. Thank you so much, sir. I would also like to extend my gratitude to the respected members of Kelly Management for their blessings. Dr. Prabhakar Kore, sir, Chairman of Kelly Society, Mr. Mahantesh Kavadgimat, sir, Governing Body Chairman of Kelly College of Law, Member of Legislative Council, and Chief Whip of Government of Karnataka. Dr. J.M. Malika Arjunaya, sir, Principal of Kelly Society's Kelly College of Law, Bangalore. and the director of Kelly Law Academy, Bangalore. A big vote of thanks to our respected principal sir, Professor Dinkar Gitte sir, for giving us this chance to be present in such a wonderful session. My heartfelt gratitude to all my dear teachers for their constant support and guidance. Thank you to the whole team of webinar for making this session a success. And last but not the least, to the most important part of our webinar, our participants. Thank you once again. Thank you one and all.
Thank you, Khushbu. Thank you, sir. With that, we come to the end of the session. One announcement for all the participants. Our college is hosting a online National Law Festival from 17th to 28th of November. Uh, and we have forwarded the details to almost all the colleges. If anybody is interested, anyone has not received the information, you can contact the coordinators, the student coordinators or the teacher coordinators. The details were already given in the brochure. Thank you, everybody.
Thank you.
Thank you, sir. Thank you.